Good afternoon. We've just got a couple of moments to go before we start, but I think we're nearly at 1 o'clock. 4 o'clock now. So we'll get going. So first of all, I just wanted to introduce myself. My name's James Catlin. I'm the Lettings Manager at Michael Jones Lettings. And today I just wanted to speak to you about a few essential updates, really. Section 21 notices, EPC regulations, Eicr, electrical safety regulations. But first of all, I want to start by thanking you. Thank you for joining us this afternoon. We know you've taken some time out of your day, so it does mean a lot for you to do that. So thank you for joining me. Hopefully, this is going to be not only prove interesting to you, but also prove of benefit, whether it is either clarifying some answers to the questions you may have, or indeed whether it's just reinforcing knowledge you already did have. But hopefully you will take something away from this. I suppose a good question and a good place to start is, why did we pick lettings legislation as a subject? And it's really because it is such a prominent issue within our industry. Legislation is constantly developing, and these particular matters are the ones that we're going to focus on today. There's over 170 different pieces of legislation, so it's really an important topic for landlords and agents to be aware of. As I said, what's to come? First of all, we're going to be taking a look at Section 21 notice. So we're going to provide an update about the Rental Reform Act the government was looking into in December of last year, and the process in which, the place in which that's in at the moment. Protection from eviction is due to end on the 23rd of August. So this means that the court proceedings can once again commence. People can start taking things further in regards to possession of their properties. The landlords can start to get the wheels in motion, which is a really positive thing to shout about. We'll also talk about the Section 21 notice time frame, which is actually a slightly different date to the 23rd of August, so just something to bear in mind, but we'll cover that in more detail shortly. Then we're going on to the EPC regulations. This is really, as it says, is your EPC still valid? It's a refresher of sorts. So there's been several revisions of the EPC regulations since it came in 2008, but actually there are a few different variations that have come in, a few different changes. Of course, the EPCs last for 10 years, an energy performance certificate. So we'll talk through that in a bit more detail as well. And then we've got electrical safety certificates and the regulations, EICRs, electrical installation condition reports, to talk about as well. That's the most modern and most recent legislation, should I say, that came into effect as of 1st July, so a most prominent one probably. A quick roundup of the matters we discuss. We'll end this before we then start a Q&A. So if you have any questions, please feel free to ask them, and don't feel as though you need to wait until the end to ask those questions. You can send through any questions you may have throughout this presentation. And as I say, you can then, I'll then be able to answer them at the end. They'll just be saved in a section on the computer here. So I'll see your questions upon the end, be able to click on those and hopefully answer those. But if you do have any further questions either out of this time or indeed later on, please feel free to give me a call. The office number's here, 01903 213 111, or indeed you can pop me an email. My email address is jamescatlin, the surname Catlin, at michaeljones.co.uk. As I say, I'd be more than happy to answer any questions where I possibly can. Starting off then, Section 21. So this is sort of the initial process. This is the usually is a 2 months notice that a landlord would serve on a tenant, or indeed their agent would serve on a tenant, asking them to vacate a property. And what the government said in 2019 is they wanted to have a look at the process to see whether it was indeed fair, whether it needed to be modernised, and so that's really what they wanted to have a look at. They wanted to check whether no-fault evictions needed to be abolished. And no fault eviction is called this because a landlord can simply serve a Section 21 notice to a tenant, giving them 2 months' notice under usual rules, but we'll come into that in just a moment. But serving us 2 months' notice on a tenant to end past the end date of their fixed term, and the tenant will be asked to vacate. And there's no reasoning required. You can have a perfectly good tenant paying their rent on time, that's looking after the property, but the landlord can serve notice on them. So that's why the government wanted to take a look at that particular matter. But also, what they wanted to do on the flip side of things was say, well, actually, do we need to review the process? Do we need to give landlords more rights to gain possession? And so they wanted to have a look in to see whether there are better processes, better ways that they can do it. And that leads nicely on to point 3 here. They want to improve the court process for landlords. So what they want to do is have a specialist housing court, or indeed sort of a specialist section that would be able to streamline the processes that are currently in place. On the Property Mark, so the Association of Residential Letting Agents, of which we're members as an agency, they made representation. They said that specialist courts must be in place first. So what they've said is that actually, yes, by all means, review the processes, but we need to get a court in place first to ensure that actually they can, that the processes can be streamlined, that landlords still have confidence in the system. They did comment that actually a Section 8 notice, which is part of the current procedures that you can pursue a tenant to gain possession of a property upon the end of the tenancy, it's not actually used very often. People find that it's too costly, and the process is quite complex as well. It has different grounds in which you have to serve a notice, so it can be a little bit more complex, as I say. Leading on, I mean, some interesting facts that actually come from ARLA, as I say, the Association of Residential Letting Agents, is that over 50% of agents that are members with ARLA say that they serve less than 10 Section 21 notices in 2 years. There's a couple of things you can take from this. One is that, thankfully, there seems to be little reason why people are looking to gain possession of their property, that those hopefully that means that there's a good, stable market out there, that tenants are paying their rent, they're looking after properties and so on. So there's a good aspect to take from it there. But leading on, 39% of members, nearly 2/5, so they haven't issued no Section 8 notices in 2 years. And that really does tie in with what Arla was saying previously about it being quite a complex process. But again, there's 2 ways you can read that. You can read it as a really positive thing. Wow, fantastic, 40% of agents haven't had to serve a Section 8 notice. Or because it's quite complex, a little bit more costly, perhaps people have steered away from it. So it depends how you do read these statistics. Out of the agencies that have served notice under a Section 8, and indeed throughout the court process, 48% of the members have said that a single hearing, so ultimately getting possession of the property, has cost anywhere between £1,000 and just shy of £5,000. So it is a costly expense, and that's why the government really want to take a look at things to see what can be done to make the process a bit more smooth. So where are we at the moment? Well, actually, and I will read this off the notes here because it was just announced this morning. So it's estimated that current process, by the way, is taking 12 months for possession to be granted from start to finish due to a backlog with the coronavirus and the courts being shut down, but we'll come into that in just a second. So there is a slightly extended process there. But the news in today is that the government has said that they want the market to stabilise, the lettings market to stabilise before they actually take a look at the renter reform bill again. And actually what they said is the earliest, it's completely off the table now, it's not going to be discussed at all. And the earliest that they want to bring it back onto the table is mid to end next year, which means that even if it's brought back onto the table in the middle of next year, we're likely not to see any considerable changes to the Section 21 procedure until the early part of 2022, at a guess. Of course, we'll certainly let you know if and when we find out more about that process and what they decide. So as I was saying just a moment ago, the protection from eviction is ending on the 23rd of August. So what the government did as part of the Coronavirus Act, when they were changing various different things, as you would well imagine, they had a look at the most vulnerable people, tenants in some instances, and they said, right, well, what can we do to give them a bit more security? Well, one, courts have been shut. So actually, they suspended any court proceedings until the 23rd of August. So that has happened, but it can commence again from the 24th. So landlords will be able to start those proceedings. Section 21 notices, apologies, you will note here it says from the 23rd of August, Section 21 notices and eviction processes can continue as normal. That Section 21 notices part actually is incorrect. It should state from the 30th of September, the Section 21 notices will be able to proceed as normal. And there's a two-part here. The eviction process, as I say, is correct. On the 23rd of August, that is ending. So landlords will be able to start the legal proceedings if they're going down the route of a Section 8 notice or accelerated possession. But Section 21 notices will revert from a 3-month notice, which is what the Coronavirus Act did. It extended the time that landlords had to give to tenants to serve notice. And it will revert back to a 2-month notice period as of the 30th of September at the earliest. It is yet to be finalised, but the current legislation in place extends it to at least the 30th of September. So it's just something to be aware of, is that up until the 30th of September at least, you will have to, or your agency will have to look to serve notice of 3 months up until that point, possibly longer, but we'll have to see what advices, what rules are made in that respect. And as it does continue to say there, yeah, due to the COVID backlog, I'm afraid there are delays to the eviction process. And what we'd usually see is 6 to 8 months being the usual process. But actually, this is likely to be closer to 12 months in the current situation. EPCs. So the EPC regulation, the Energy Performance Certificate Regulations, 2008, they made it a requirement. So this was part of the Home Information Pack, or the HIPS, but this is one part that they kept of it. And what they do is, I don't know if you've seen sort of the light bulbs or fridges or cookers, washing machines, etc. But you have the sort of the A to G rating on the side of them. And it basically tells you how efficient an item is, or in the case of property, how efficient a property is. And the EPC regulations came into effect in 2008, and they basically said that anyone selling or anyone letting a property, they must have a valid EPC in place to be able to do so. Now on sales, that's remained largely unchanged. You just need to have a valid EPC. On lettings, the regulations have been revised a couple of times, and what they're trying to do is get the efficiency of the properties increased to ultimately make tenants' bills cheaper and to help the environment at the same time. Now, the reason why we've decided to cover this subject is because it is quite relevant, actually. The regulations changed yet again in April of this year, but also actually 2008, 2009, 2010, all those EPCs, they've now expired. So if you do manage a portfolio yourself, if you have a couple of properties, perhaps, or even just one, it's worth making sure that the EPC you have is in date. You can do this yourself, or indeed you can ask your agency. Go onto the EPC register. I think it is simply epcregister.com, but go on Google and just type EPC register and you'll come up with a government website that will allow you to search for the EPC via the postcode of the property. So it's quite straightforward. So the EPC lasts for 10 years. So one thing to note on this is that perhaps if you purchased a property in 2015, you might make an assumption that the EPC would be valid until 2025. Now, whilst that is possible, indeed, if it was the first time the property had been sold since regulations came in 2008, indeed it is possible that the EPC will be valid until 2025. If the property had been bought and sold since 2008, it is possible that actually the EPC has expired if it was purchased between that time, because when you bought it in 2015, they were still using the EPC that was valid then. So again, just a point that's worth checking on that. Now, as I said, the EPC's regulations, they have been revised, and in 2016, 2017, the minimum rating started to come in. So the EPC minimum rating now must be of an E rating or above. So it's just, again, another point to note when you're looking at the EPCs. This is something that, again, as an agency, we take into account when marketing a property, when renewals are coming into effect, and so on. But it has had an impact on month-to-month tenancies or periodic tenancies with the latest change in regulations. So as of April of this year, irrelevant of when the tenancy started, whether the contract's been on a periodic tenancy since, you must now have an energy performance certificate that is valid and in place, assuming it's not in another exempt sort of regulation, but we'll come up to the exemptions in a moment. But yes, as I say, all tenancies, irrelevant of when they started now, must have an EPC. That was part of the revision of this year. There are some exemptions, as I just said. So a couple of the exemptions then. If all the improvements have been made to the property and you can't possibly improve it anymore, no matter what work you did, but it's still not above an E, then you can apply for exemption. Makes sense? There's a high cost exemption. I imagine before you got to number A, before you got to the one I just mentioned to A, you'd probably be coming under category B first, and that's a high cost exemption. So if you as an individual have to spend over £3,500, but it's still not improved to an E rating or higher, you can apply for an exemption. Again, just another thing to consider there. Wall insulation exemption. Now this is a peculiar one, but an architect, a surveyor, they can go to your property and they can say, actually, the type of walling, type of walls you've got and so on, it's not suitable for this type of insulation. And that may well be the only type of insulation that get the property up to an E rating or higher, and therefore you can apply for an exemption under that reasoning. A couple more. Third-party consent. So if it's a block of flats and the freeholder can't be contacted, then again, consent as an exemption could be applied for there. Property devaluation. Now this one has to be, it can't just be someone's own opinion that the property would be devalued if it was improved, perhaps by having solar panels or similar. It has to be a surveyor who would go around to the property and they would assess it and say, right, well, actually, no, you are right, by having solar panels, although I imagine for most people they'll actually improve the value in some respect, because it would mean the new occupant has lower emissions, lower bills every month. But say, for example, it was the case, if it was to devalue the property and a surveyor said so, you could apply for an exemption. And then finally, a temporary exemption due to becoming a landlord. So this is a bit of a peculiar one, because if property is being sold, it should have a valid EPC. So it's unlikely you wouldn't have a valid one. But there's a thing to note here, is that, of course, you could buy a property where the EPC was below the E rating, and therefore it would be, you couldn't let it out until works were completed. So if you buy a property of a tenant in situ, although they should have a valid EPC and it should be in place, it's worth just making sure that your estate agent or your solicitor is checking the EPC to ensure that you don't fall into this category, because you will be required to eventually do those work. It's only a temporary exemption, so just something to be aware of. Certainly here, we communicate with our sales team to ensure that if we know of a buy-to-let investor buying a property, we'll be having that conversation as to whether the EPC is valid, how much work may be required to get the property up to the minimum rating. But as I say, it's just worth bearing in mind when purchasing a property for investment. Electrical safety standards in the private rented sector. So this has been something that has been anticipated for quite a long time in our industry. And the question here, how are you impacted? Well, everyone should be impacted by this, because it is a regulation and hasn't only come into effect as of July the 1st on all new tenancies, but it will work retrospectively from April of next year as well. And what the regulations say is that an electrical installation condition report, an EICR, must be in place, valid, so it lasts for 5 years. It must be valid and say the report is satisfactory, the electrics are satisfactory for all new tenancies as of July the 1st. As I say, it will work retrospectively as of 1st of April 2021. So all existing tenancies will come into that category afterwards, and a valid EICR must be in place. And what's our advice on this matter? Well, our advice is simply deal with this. Don't leave it on the back burner for the next 8 months or what have you. It's probably not worth doing it and not worth having the stress. As an agency, we've taken the decision to be proactive about this point. We are already contacting our landlords, advising them that we will be looking to get the EICR completed at the earliest opportunity. And so we're working through our portfolio at the moment. So if you haven't been contacted, you soon will be, and we're working for our portfolio to make sure that these EICRs are in place, they are ready. And ultimately, the reason why the industry's been waiting for this is because it's ensuring the safety of tenants. And I'm sure that any landlord would agree that that's got to be an important factor when you're considering to let a property. Indeed, we've always, certainly I as an individual, I've always recommended that landlords get an electrical safety certificate when letting out their property. It's the only way to know that the electrics are safe. So it's just one thing to bear in mind. Now, if your current agency, if you are with another agency, or perhaps if you manage property yourself, hasn't had a conversation with you yet about this matter, or perhaps you haven't looked into it, it is probably worth getting a hold of this now. As I say, getting it in hand before April comes around, and it will come around quickly. We all know how quick this year's gone through various different reasons. So it's worth just considering now. So as I say, Section 21 notice update. So just an update that actually there is no update. Everything is on hold, and it will be until at least June or July next year. It's middle of next year that it will then be put back onto the table potentially. But even then, even if that is the earliest date it comes back on the table, we're probably looking at a good few months before a new system is put into place. So watch this space. We'll certainly update you in due course. Protection from eviction. So under the Coronavirus Act, the courts have been temporarily closed. No proceedings have been able to go ahead in regards to possession. However, as of the 24th of August, 23rd being the end date of the current rule, as of the 24th of August, landlords can start to go down the route of illegal possession through the courts. One thing to note is that Section 21 notice period, changing from a 3-month notice period back to a 2-month, as it was temporarily increased, will be in place until at least the 30th of September. So just bear that in mind. EPC regulations, basically just check that your EPC is currently valid. That would be my advice. It could be that it's just been missed. Certainly as an agency, it's something that it's all automated via our systems, and my colleague Sue will regularly go through and make sure that everything is updated, and every 10 years they are being followed up, making sure that they've got the minimum requirement and so on. But it's worth just checking if you do have a few properties that you manage yourself. It's just something worth bearing in mind. An electrical safety certificate. So do you need one? Yes. As of the 1st of July, all new tenancies must have an EICR. It must state it's satisfactory, and therefore it mustn't have any category 1 or 2 issues. They must be rectified if they show up. As I say, it will work retrospectively, so as of April next year, an EICR will be required on all properties, irrelevant if the tenancy has been a month-to-month tenancy, whatever the circumstance may be, it will be required from next year. So we'll start then with some Q&As. If you've got any questions, please do let me know. But we'll start off here first of all. I've got a question here about rent arrears and the process here. So I'll just read this first of all. So if tenants rating clear. Yeah, so it's a very good question, and it's been all sorts of circumstances that have arisen due to coronavirus. Thankfully, furlough has obviously played a massive role in making sure that tenants are able to pay their rent in most circumstances, and indeed tenants who perhaps are in a bit more of a difficult situation. I know there was little assistance at first for self-employed tenants. Well, thankfully that seems to have changed now, but at least there has been some assistance there. In this particular question, the individual's asking about universal credits, perhaps if the tenant hasn't paid the universal credit over to the landlord. And the individual is correct here. Yes, 2 months. If a tenant is 2 months in arrears, then you are able to actually apply to have the payment made directly to you. So hopefully that should stop any further issues from occurring, depending on how much the government does pay out of your rental amount. It's one thing worth bearing in mind, though. Perhaps I don't know in this circumstance what questions, what conversations have been had with the individual if they are still receiving the housing benefit, the universal credit, why they're not paying it on. It's worth having a question. Certainly something that I'd be happy to do if it was a managed property. So please do get in contact with me if it's something that we look after, or if you want a bit further assistance on that. So thank you very much for the question. I recognise the name of this individual here. Thank you very much for your question. How much will the electrical certificate cost, and can any electrician do this? As long as they are a qualified electrician, a Part P qualified electrician, they will be able to carry out an EICR. As a company, we've got a flat rate. We've been able to communicate with a lot of electricians, get the best rates possible. So it's £150 plus VAT per property, and that's relevant of size. So whether it's a 5-bedroom house or a studio or 1 bed, it's just a flat rate. Now, the electrician will go round, and what we're asking landlords is for an extra budget, basically, of about £150 on top of that actual cost for the inspection and the report. And the reason being is that there are several instances, and it's another question I've got actually, about the issues arising during the EICR. How common are little problems? Well, they're not especially common, you'll be delighted to know, but when they do come up, they're often quite a small thing to resolve as well. One that I've seen a couple of times is about the fire rating on spotlights. So obviously a lot of places in kitchens and so on have got spotlights, and often the rating on them, while it was correct a few years ago and valid, then it did meet the regulation, it doesn't now, and so a couple of those are having to be changed. And in those instances, they're often below the 150 threshold, and it means that we can get a pass certificate straight away if the electrician's able to do those minimal works there and then. So it saves a call out, speeds up the process, it saves having to arrange an appointment again with the tenants. So it's a win-win for everyone in that respect. So yeah, certainly a good question. Thank you very much. I have got just a couple more questions here. How long is an electrical certificate valid for? And the answer to that question, thank you very much. It's valid for 5 years. Even if the certificate states 10, which some electricians may do on new builds, you may have seen that the installation certificate says it's valid for 10 years. Well, under the new regulations, if it's a let property, it must be checked every 5 years. So that's just one thing to bear in mind. And I think I've probably answered the other question in regards to any additional works that may be required from the certificate. Yes. Any category 1 or 2 risks, they must be addressed to ensure that the certificate can come back as a valid, satisfactory report. So that's just one thing to bear in mind. Thank you very much for that question. I've got a current client of ours saying that she manages, we manage a property on behalf of her. Yes, we will prompt you in regards to the next steps with regards to the renewing of contracts, EPCs, electrical installation condition reports, gas safety if your property has gas in it as well. And we are going to be looking to start physical inspection. So at the moment we're doing virtual tours in line with government advice to minimise the amount of times we're going out to properties. So we will look at those sort of options of starting to go back and doing physical inspections as well. But again, that will be once the government says that actually it is a smart thing to be doing that, and once the world has really progressed to that sort of stage, I suppose. So thank you very much for those questions. If we have a valid EPC for 2012, does that mean it is E-qualified? Well, the rating will the rating system has changed slightly, but if the EPC on there, if the rating is an E from 2012, so if you've got your certificate and it says E, then yes, it will be a valid certificate. Assuming it is an E, and obviously it's done in 2012, so it's just worth making a note in your Android phone, Apple phone, whatever it may be, or on the calendar itself, 2022, just saying you need to get that renewed when it comes up for renewal. If you get the certificate done before April 2021, when does the validation end? Well, it is 5 years. So if you get the certificate completed tomorrow, then it will be in July 2025 that the electrical installation condition report would expire. That's a very good question. But yes, it's 5 years from the date that it is completed, much like a gas safety certificate or similar. Just on another question then, reason why we haven't covered gas safety regulations in this particular subject, and believe me, it's not that it is any less important at all, is because the regulations, they haven't changed. So it's not something that we felt the need to discuss, but quite simply put, a gas safety certificate where there is gas supplied to a property and appliances within the property, it must be valid, so it must list the property as being safe. A gas safety certificate lasts for 12 months and it must be supplied to the tenant. And I suppose all these matters, they do tie in very nicely with the fact that without having a valid EPC, without how to rent guides being provided to tenants, without a gas safety certificate being valid and given to tenants, and without electrical certificates now and so on being provided, you can invalidate serving a Section 21 notice altogether, which would leave you only with the option of pursuing a tenant via Section 8 and through the courts to gain possession of the property. So it's really critical that these matters are handled correctly. I don't think we've got any other questions coming in, so I will thank you all for your time and attention this afternoon. I really do appreciate it. And certainly if you have any other questions, as I've said already, please feel free to give me a call, the number 01903 213 111, or indeed you can email me. The email address is James Catlin, surname Catlin, at michaeljones.co.uk. And thank you very much for your thanks. I do appreciate that. Thank you.